Thank you to Dennis for inviting me to speak at this year's Putney Debates. I'm going to be speaking today about the UK and devolution, federalism, and the differentiated state. And I'm starting with the point that Britain is not a federal state, but a devolved state. Devolution is a device that transfers power from the centre without relinquishing sovereignty. This feature distinguishes it from federalism, in which sovereignty is usually divided between a federal centre and various state territories. Federalism, understood broadly, has a long history. In ancient times, there existed alliances such as the ancient Greek Achaean and Amphictyonic leagues, although these were as much confederal as federal. Federalism in its modern sense was born in the USA in the late 18th century, conceived as a means of dividing power to ensure greater liberty and preserve both central and state governance. Federalism is widespread in the world today, existing as the main mode of governance in many countries, for example, in Australia, Belgium, Brazil, Canada, Germany, India, Malaysia, Mexico, Nigeria, Russia, Switzerland, and the US, but not in the UK. Daniel Elazar defined federalism as a combination of self-rule plus shared rule, one of a number of definitions of federalism, which I find helpful in its simplicity. But part of the problem with defining federalism is that there exists a great variety of federal states today, differing both in the size and number of the sub-state units. But they have in common a division of sovereignty between state and federal centre, a protection against a central government becoming too powerful. This division doesn't exist in the UK. So I move on to UK devolution, and the UK introduced devolution in 1998 as a means of according greater power to its constituent nations. Before 1998, the UK was a fairly centralised state, but with some diversity due to its different historical relationships with Scotland, Wales, and Northern Ireland. For example, although Wales had been absorbed into the English legal and administrative system by the 16th century, Scotland was an independent state until 1707, when it chose to enter into a union with England. Under that union, Scotland retained its separate legal and education systems and church, and parliamentary sovereignty was simply not mentioned in the Acts of Union of 1706 and 07. Ireland was different again, having first been subject to constraints and supervision from London, and then from 1801, having been in an active union with the UK, until the greater part of Ireland became independent in 1922. However, Northern Ireland remained in the UK, operating an early form of devolution until its parliament, Stormont, was abolished in 1972 and direct rule by Westminster established. By 1973, the Kilbrandon Report on the Constitution suggested that representative institutions be set up in Scotland and Wales. But due to the addition of a last-minute threshold requirement, the 1979 devolution referendums in Scotland and Wales were lost. It took almost another 20 years for devolution to come to Scotland, Wales, and Northern Ireland. And this resulted in the 1998 Devolution Acts, which consisted of the Scotland Act 1998, the Government of Wales Act 1998, and the Northern Ireland Act 1998, which domestically implemented much of the Belfast Good Friday Agreement. Although initially these devolution settlements were different in nature, subsequent amendments changed this, although devolution has always operated somewhat differently in Northern Ireland. Perhaps oversimplifying matters, we might summarise the present situation in the following way. First, each devolved nation has a devolved parliament or assembly with legislative powers, elected on a wholly or partial proportional representation basis, and a devolved government. Second, these legislative powers are limited in number, with certain matters reserved to the Westminster Parliament. Third, there exists no completely autonomous sphere of self-rule within the devolved nations, as UK sovereignty has been preserved in all matters to the UK Parliament. In this way, devolution was crafted to protect parliamentary sovereignty. Nonetheless, the Sewell Convention was generally applied, according to which Westminster will not normally legislate with regard to devolved matters without the consent of the devolved parliaments. And indeed, this convention was written into legislation in the 2016 Scotland Act and 2017 Wales Act. However, since Brexit, the status of the Sewell Convention has become questionable, since the lack of devolved parliamentary consent was ignored when major Brexit legislation was passed in Westminster. Devolved funding is provided largely through the block grant, which apportions funds from the UK's Consolidated Fund, which is the aggregated tax revenue from all four nations. Devolved governments can choose how to spend this according to policy priorities. Changes to the allocation of this funding are calculated according to the Barnett formula, which reflect per capita changes in UK government spending on comparable public services in England. Although most taxes are set by the central government in London, devolved governments also have tax-raising powers of their own. So, for example, about 31% of total tax revenue is now devolved to Scotland. This means revenue from some taxes goes directly to the devolveds, and their block grant is proportionately reduced. However, the UK government can also circumvent the Barnett formula altogether, as it did with £1 billion funding for Northern Ireland, delivered as part of the Conservative DUP Confidence and Supply Agreement from 2017 to 2019. Although the Scottish and Welsh governments objected to this, their attempts at a legal challenge failed. The UK Internal Market Act of 2020 also gives the UK government the power to spend money directly in devolved areas, or through the UK Shared Prosperity Fund, even where it doesn't have policy competence over those areas, and without the consent of the relevant devolved ministers, a matter that has become contentious. However, England, the largest of the UK's four nations, lacks its own parliament. This was seen as giving rise to the West Lothian question, named after the West Lothian constituency, whose MP Tam Daly raised the issue. And this question arises when MPs elected to Westminster from devolved nations can vote on matters in England, such as education, which are devolved competences in Scotland, Wales, and Northern Ireland, and so on which English MPs had no vote for those territories. The day after Scotland's first independence vote in 2014, then Prime Minister Cameron announced outside 10 Downing Street that the question of English votes for English laws required a decisive answer, and that any powers for Scotland must be balanced by a reassessment of the voting power of devolution MPs at Westminster. This at one and the same time seemed to downplay the issue of greater autonomy for Scotland, and also concretised into the issue of English votes for English laws, shortened to be EVEL, E-V-E-L. A new procedure for EVEL was introduced as a 2015 reform, which brought changes to standing orders of the House of Commons. Notably, this highly complex change gave English MPs a veto power over legislation concerning England only, but was not a form of devolution to England. It was in any case abandoned in July 2021, and to date there's been little demand for English devolution. The problem of how, if at all, England fits within devolution is sometimes referred to as the English question. The last 2 decades have seen a gradual dispersal of powers to devolved territories, although the UK is still not a federal state, despite Vernon Bogdanor's description of the UK as quasi-federal in 2001. Devolution is a bit of a mixed picture. On the one hand, 2 factors about the way devolution evolved illustrate how it might seem to challenge parliamentary sovereignty. First, very generally speaking, a reserved powers model of devolution now operates in Scotland, Wales, and Northern Ireland. This means all legislative power is devolved, except those matters expressly reserved to the UK. And a considerable amount of power has been devolved. For example, in Scotland, most areas have been devolved, except defence, foreign relations, currency, the constitution, social security, immigration, citizenship, trade, and most of income tax. Secondly, it's also worth noting that in the earlier years of devolution, the UK government operated a fair amount of what's been described as permissive autonomy. which meant considerable self-rule by devolved institutions. In this respect, UK devolution looked to have given rise to something akin to the self-rule of federalism, with quasi-sovereign institutions in its devolved territories. Yet, on the other hand, UK devolution always lacked the shared rule that characterises federalism. Reserved areas in the UK tend to overlap with powers that are often shared under federalism. But with devolution, all the reserve powers are exercised by London, and relations between the UK government and devolved governments remained almost entirely informal, based on concordats, memoranda of understanding, and a somewhat dysfunctional joint ministerial committee of executives that rarely met before Brexit. Devolved institutions lack enforceable legal powers in these areas. Even legislative relations between Westminster and the devolved parliaments have been regulated by the informal Sewell Convention, by which the UK Parliament will not normally legislate on devolved matters without the consent of the devolved legislatures, a political convention which, even after its translation into legislation, was nevertheless held by the UK Supreme Court, almost inexplicably, to be nonetheless a mere convention and not legally enforceable. This lack of shared rule means that, for example, devolved seem to be in a weak situation when it comes to international affairs, including Brexit, but treaties more generally. In 2021, the UK Supreme Court upheld the UK government's challenge to two bills adopted by the Scottish Parliament on grounds they exceeded the Scottish Parliament's powers. Both bills implemented treaties into Scots law, one incorporating the UN Convention on the Rights of the Child, the other the European Charter of Local Self-Government. Although both bills were unanimously approved by MSPs and certified by the presiding officer as within the Scottish Parliament's powers, the Supreme Court held that both bills placed obligations on UK ministers that exceeded devolved powers. This absence of shared rule also means that the UK government has, over the past few years, refused to accept that Scotland might have any power to hold another independence referendum, insisting this falls within reserved powers and is for the UK government alone to determine. All in all, there's something to be said for the description, by Sandford and Gormley-Heenan, of Schrödinger's devolution, namely the idea that since 1999, Scotland, Wales, and Northern Ireland both have and have not experienced fundamental constitutional change, on which claims to territorial autonomy can be founded. I'm now going to talk about the concept of a union state, because as well as being a devolved state, the UK is often described as a union state. This term is normally used to distinguish the UK from both a federal and a unitary state. But why is the UK not a unitary state? That latter term implies a unified state with a unitary political centre, shared governing institutions, and legal and administrative standardisation, an overall undifferentiated polity. In contrast, the term union state denotes the state where the centre does not directly control every part of the territory. The UK is composite in nature, and a plurality and diversity of arrangements exist over its composite parts. The case for UK as a union state can be illustrated by the following points. First, there exist different constitutional settlements in the different parts of the UK. The Union of Scotland and England was the founding act of the United Kingdom of Great Britain in 1707. Under that union, Scotland kept and still keeps its own legal system, church, and education system. Since 1998, the UK's devolved nations developed some distinct constitutional forms, such as the proportional representation electoral system that challenges the unitary constitutional approaches of the centre. Third, the Scottish and Welsh parliaments are described in legislation as permanent, which, if it's to be taken at all seriously, surely undermines the doctrine of unbounded Westminster parliamentary sovereignty. Northern Ireland has distinct constitutional arrangements, some mandated by the Belfast Good Friday Agreement, involving a consociational form of government, about as far from the first past the post system operated by Westminster as is imaginable. The Brexit Northern Ireland Protocol distinguished Northern Ireland further. Such variegated devolution illustrates diverse constitutional narratives. But Brexit has certainly posed a problem for devolution. UK devolution took place after the UK joined the EEC, now the EU. Somewhat ironically, EU membership insulated devolved nations from a unitary UK-wide approach by, for example, distributing EU funds on a basis more beneficial to some parts of the UK than others, as with agriculture. Brexit risks undermining an already brittle devolution settlement. In the referendum on the UK's EU membership, the UK as a whole voted to leave. However, 62% of Scotland's voting electorate and 56% of those voting in Northern Ireland voted to remain. Yet the devolved nations had no formal role in the Article 50 withdrawal proceedings, and thus no means of ensuring their constitutional interests were protected. Although the SNP had argued in Westminster there should be majorities in all four nations for a decision to leave the EU, this approach was rejected by the UK government. The UK's departure from the EU caused a major change to the UK constitution. But unlike the case for amendments to federal constitutions, there was no requirement for devolved participation in or consent to this major constitutional change. The devolves were similarly unable to play any important part in the Brexit negotiations due to relations with the EU being treated as a foreign policy matter and thus a reserved power for the UK government. This was despite the Scottish government's separate and distinct proposal, Scotland's Place in Europe, which argued for a continued single market membership for Scotland, possibly through the European Economic Area. Now, a fairly early indication of problems to come was illustrated by the EU Withdrawal Act 2018. This gargantuan and complex piece of legislation had the task of preparing UK domestic law for the post-Brexit world and transferred most EU laws into domestic law in what's been described as a massive cut and paste exercise. However, as noted, UK devolution operates on a reserve powers model, which appeared to be undermined when in the act of taking back control from the EU, UK government legislation, in an earlier draft of the 2018 EU Withdrawal Act, expressed an intention to return legislative authority to Westminster by default, even if the powers in question were devolved, such as agriculture or environment. This was justified as necessary to ensure a functioning UK internal market post-Brexit. But even a redraft of the relevant provision couldn't persuade the Scottish government to grant its legislative consent to the EU Withdrawal Act, nor prevent accusations of a power grab by London. Indeed, subsequently, the Scottish Parliament was joined by the Welsh and Northern Ireland legislatures, all of which refused consent to the 2020 EU Withdrawal Agreement Act. This didn't stop that legislation from being adopted, given that the UK Supreme Court held in the first Miller case that the Sewell Convention, even set out in legislation, nonetheless remained a convention only and not legally binding. It was therefore legal for the UK to adopt legislation in the absence of consent from the devolves. Legal, but possibly not constitutional. There was also the question of how a UK internal market is to be sustained after Brexit. Federal states have specific provisions to ensure their internal market policy harmonisation. For example, the German Federation has exclusive powers under Article 73 of the German Constitution, although the German Länder also have considerable competences of their own, some including treaty making. Many federal sub-states have some involvement in treaties, and this includes both US states and Belgian provinces. The UK Internal Market Act 2020 attempts to provide a basic framework for the UK internal market post-Brexit. It relies on two major principles, that of mutual recognition and non-discrimination. Although devolved nations may see their own regulations and may set their own regulations in devolved areas, the mutual recognition provision prevents them from applying these to goods and services already marketed in other parts of the UK. This also extends to goods imported into the UK from third countries such as the USA. The non-discrimination principle prohibits devolved governments from enacting laws that discriminate against goods and services from other parts of the UK. Overall, devolved governments view the Internal Market Act as weakening their ability to legislate in devolved areas. Furthermore, the Internal Market Act also provides the UK government with spending powers in many devolved areas, thus compromising devolved's ability to take credit for funding policy innovations within their territories. But the Northern Ireland Protocol in particular raises all sorts of issues of differentiation. Although the UK government declared that the UK would leave the EU as one state, the Northern Ireland Protocol has undermined that. The prospect of a post-Brexit external border between an EU state, namely the Republic of Ireland, and non-EU territory, namely Northern Ireland, was a fearful reminder of the role that border played in the violent recent past during the Troubles. There's also a certain irony in this predicament. In the 2016 EU referendum, the majority in Northern Ireland voted to remain in the EU, but it was the Brexit-supporting DUP that supported former Prime Minister Theresa May in power from 2017 to 2019 that urged a troublesome hard Brexit, and in 2021 was incensed by the inescapable result of that approach. This pressing and seemingly intractable problem was solved by the protocol attached to the withdrawal agreement agreed between the EU and Boris Johnson's government in 2019, after Theresa May's earlier solution of the backstop had been rejected. This third version of the protocol basically transferred new regulatory and customs processes to the Irish Sea. Under the protocol, Northern Ireland remains in the EU single market for goods. Northern Ireland also applies EU customs rules, although it's still officially part of the UK customs territory. Therefore, border checks are now focused on trade between Britain and Northern Ireland, apparently distinguishing Northern Ireland from the rest of the UK, a solution found abhorrent by Ulster Unionists. UK Prime Minister Boris Johnson deliberately opted to put a border between Great Britain and Northern Ireland, rather than taking the alternative mooted option of keeping the UK in the EU customs union. This has led to a very clear fragmentation of the UK's internal market, with Northern Ireland applying different rules. In this way, Brexit ideology and the perceived need to maintain absolute UK sovereignty by leaving the EU altogether were prioritised over the peace process in Northern Ireland and, somewhat ironically, the UK's constitutional integrity. Unionists in Northern Ireland became very dissatisfied with the protocol, sometimes described by them as the Betrayal Act, which they believed undermined the constitutional integrity of the Union by placing a barrier between Great Britain and Northern Ireland. This has led to some violent incidents. For its part, the EU was not satisfied with the UK's enforcement of the protocol. This is partly because trade disruptions were so severe that Britain unilaterally extended the grace period for food and horticultural products. It's very hard to see how Northern Ireland can be controlled by two different customs systems without considerable disruption to trade and increased red tape and bureaucracy. So the situation created by the protocol appears precarious and unsettled. Yet there appears no palatable outcome. A hard border across Ireland would be ruinous for the peace process. On the other hand, it seems unlikely that either the UK or EU would allow infringements of their respective markets. The only other resolution would appear to be greater unity for Northern Ireland, either with the UK by placing the hard border across Ireland, or with the Republic through a unification referendum under the conditions of the Good Friday Agreement. Either course of action would inflame a sizable proportion of those in Northern Ireland. Boris Johnson described Brexit as the greatest single restoration of national sovereignty in parliamentary history. Yet the UK, in signing both the Belfast Good Friday Agreement of 1998 and the Northern Ireland Protocol, has adopted international agreements that do not accord with this absolutist version of sovereignty. Both these agreements created a hybrid identity for Northern Ireland and differentiation within the UK. So, why not opt for a federal UK after all? The word federal is not unheard of in the UK, in spite of being derided as that F word when used in an earlier draft of the EU 1992 Maastricht Treaty. In the late 19th, early 20th century, British imperial federalists argued the empire must, and I quote, federate or disintegrate. But the imperial federation movement didn't succeed, nor did its close relation, the Home Rule all-round movement for the UK in the early 20th century. On the other hand, the British Empire did disintegrate, not so much later. The UK faces similar dilemmas today in coping with competing centripetal and centrifugal forces. In the post-Brexit context, some of those troubled by the UK's constitutional future, who fear the union will shatter, but don't favour independence for the devolveds, have suggested a federal UK. Although the UK Liberal Democrat Party has long favoured a federal UK, most other parties, or the political parties, have not tended to do so. However, post-Brexit, things might have changed. In 2016, the Constitutional Reform Group, a group with cross-party membership, including former First Ministers of Scotland, Wales and Northern Ireland, led by Conservative peer Salisbury, argued for radical constitutional change in the UK, an argument they've since renewed into the 2020s. The Constitutional Reform Group argued there should be a broadly federal system of government for Britain, with fully devolved government in each part of the UK, each with autonomy over its own affairs and the right to secede by means of a referendum. They suggested two possible options to redress the English question, either that the Westminster Parliament function as a specifically English Parliament where necessary, or further devolution to regions of England. The Constitutional Reform Group also proposed that shared UK functions, including the monarchy as head of state, foreign affairs, defence, national security, immigration, treaties, human rights, the Supreme Court, a single currency, a central bank, finance, income and corporation tax, the civil service should be controlled and shared, should be shared by the UK. Other functions of the existing UK would be controlled by the nations and regions, similar in effect to the Devo Max proposal formerly promoted in Scotland. The Constitutional Reform Group's proposals were drafted into an Act of Union bill promoted as a basis for discussion. A new version of this bill was published in April 2021. However, the Constitutional Reform Group's claim of a broadly federal system of government is surely undermined by their bill's preservation of parliamentary sovereignty. Sections 29, 5 and 6 of the 2021 Act of Union Bill state respectively that the UK Parliament continues to exercise the authority of the sovereign Parliament of the United Kingdom, and that nothing in this Act diminishes or otherwise affects the extent of that sovereignty. These provisions surely undermine the Constitutional Reform Group's bill commitment to the sovereignty of the devolved nations and to the concept of pooled sovereignty outlined elsewhere in the bill. The bill also, although intending a possible reconstruction of the House of Lords, which would reduce its membership and include elected as well as appointed members, doesn't transform it into a federal second chamber, thus missing a chance to make UK institutions more federal in nature. The Constitutional Reform Group bill also seems to lack any firming of intra-governmental measures, with a ministerial council proposed in section 52 likely to perpetuate the weaknesses of the Joint Ministerial Committee. Therefore, their bill looks likely to preserve a devolutionary system rather than instigate a federal one. Indeed, the two main obstacles to a federal solution for the UK appear to be the England problem and parliamentary sovereignty. It's long been recognised that a destabling force for federalism may be too much asymmetry, caused by the disproportionate size of one federal unit, such as Russia within the former USSR or England within the UK. A large discrepancy in size isn't unknown in federal systems. Think of California in comparison to Wyoming or Rhode Island. But such disproportion can affect the capacity of other territorial units to influence central government or to assert constitutionally assigned powers. The Constitutional Reform Group's two options for England may offer some solution to this. However, the main obstacle to progress lies with an insistence on preserving parliamentary sovereignty in the UK. David Marquand has described the UK's antipathy to federalism as a neurosis. Why do we still insist on it? The Victorian Oxford academic Dicey wrote that parliamentary sovereignty was a matter of logic and that limited sovereignty was a contradiction in terms. If true, this would rule out federalism, where sovereignty is shared between a national federal centre and states or provinces. But why? Why must sovereignty be understood only as unlimited and indivisible? Many others understand it differently. Divisible sovereignty was well understood by the framers of the US federal constitution. Dicey's answer was that sovereignty was always understood in this way in England, but there's no overwhelming evidence for this. For many centuries, there existed a different tradition of the English fundamental law, dating from medieval times. To be sure, it was often expressed in vague terms, but its essence could be distilled to three main components, namely that the law and not Parliament was legally supreme, that fundamental constitution was unwritten, and that it was also, at least on some occasions, judicially enforceable. But even if Dicey's claims regarding the English constitution were accurate, they can only be contingent, which is different from Dicey's claim for logical truth, the claim that any other interpretation is a contradiction in terms. In any case, other nations of the UK are less inclined to recognise the supposed orthodoxy of parliamentary sovereignty. For example, in the 1953 Scottish case of McCormick and the Lord Advocate, Lord Cooper stated, "The principle of the unlimited sovereignty of Parliament is a distinctively English principle, which has no counterpart in Scottish constitutional law." In April 2021, Kieran Martin, formerly the Constitution Director at the UK Cabinet Office, who helped agree the framework for the 2014 Scottish independence referendum, in a lecture generally sympathetic to the case for a second Scottish independence referendum, ruled out the prospects for federalism in the UK. Martin's argument was that UK federalism would require abolition of the ancient doctrine of parliamentary sovereignty that had been the bedrock of the English constitution for centuries. As I've argued, I think the case for parliamentary sovereignty as an ancient principle of the English constitution is less well supported than sometimes supposed, and carries even less weight if we look to Britain rather than England. Martin also, however, argued that a referendum would be required to abolish parliamentary sovereignty and move to a written constitution, and that it would be hard to find support for this in the UK. This seems a stronger argument, although the constitutional status of referendums is by no means clear in the UK. To be sure, it's hard to imagine that many English voters would agree to a permanent limitation of parliamentary sovereignty. Those satisfied with Brexit are unlikely to desire a written constitution or federal option, given that a desire for strong parliamentary sovereignty is likely to have motivated their Euroscepticism in the first place. Advocates of Scottish or Welsh independence or a united Ireland may have little enthusiasm for arrangement that would anchor them into the UK, even if it provided authoritative and legally enforceable constitutional procedures for protecting different national communities within the state. Such approaches and distinct political identities may militate against a comprehensive approach which would address issues of disputed authority and the challenges of Brexit. But between those two, between those who support a traditional concept of the British Constitution underpinned by absolute sovereignty, and those who seek an independent Scotland or Wales or a united Ireland, there may be a sizable group of people, a majority even, who desire a different constitutional settlement for Britain. But can that group be animated into action? Well, in conclusion, if such a group may be animated or inspired, putting aside the question of whether parliamentary sovereignty really does rule out federalism, there are interesting and under-researched options for the UK Union to be taken from comparative law and history. The Austrian jurist Georg Jelinek used the term state fragments to capture a more nuanced account of jurisdiction than a blunt division of states and non-states. State fragments may be nations in their own right, like Scotland and Wales, or provinces or territories within a larger state. But in either case, although not sovereign, these entities have strong political autonomy and certain state-like characteristics. One such example may be found in the concept of the Dominion, which provided practical autonomy and equality of status with Britain for some British colonies in the past. The Dominions of Canada, Australia, and New Zealand were formally granted constitutional autonomy and equality by the Statute of Westminster in 1931, without any declaration of their independent status. Although the Dominion model has been criticised, it demonstrates the possibility of self-government, autonomous from London, even in the absence of a formal declaration of independence. Another example is that of the Federacy, which has much in common with the UK's asymmetrical devolution, because federacies comprise smaller units, such as Greenland, within a larger state, at least in population terms, Denmark. However, although the smaller state shares the benefits of association with the larger polity, it retains internal autonomy and self-government. There's thus considerable self-rule, but much less shared rule than in federal states such as Germany or the USA. A further example is the Legal Compromise Agreement of 1867, whereby the dual monarchy of Austria and Hungary were co-equal partners with internal autonomy, but jointly managed foreign affairs. Now, Austria-Hungary has often been justly criticised, but its constitutional arrangements interested Scottish and Irish writers at the time, over 100 years ago, such as Arthur Griffith, who sought to demonstrate how their nation's sovereignty had not been completely overridden by acts of union. In 2012, prior to the 2014 independence referendum, Scottish Constitutional Commission discussion paper on secure autonomy for Scotland argued that whereas parliamentary sovereignty dictates Parliament may not bind its successors, and so no devolution scheme may be safely regarded as permanent, Parliament can renounce its sovereignty. This paper argued there could be a new union, which would be equal and consensual, not the incorporating union of 1707. And the paper cited historical examples of such unions in which the Austro-Hungarian example featured prominently. Such legal devices provide food for thought. UK law doesn't necessarily preclude these varied state forms which permit territorial autonomy, and surely something has to change. We're surely witnessing what Peter Hennessy describes as the end of the good chaps theory of government, or good chapesses perhaps. Britain long prided itself on its unwritten constitution, viewing Westminster as the mother of parliaments. However, as British Prime Minister William Ewart Gladstone said back in 1879, the British Constitution presumes more boldly than any other the good sense and good faith of those who work it. This is because the UK has no codified constitution and relies greatly on political conventions and understandings. It also relies on the fact that those who work within politics, civil servants, politicians, their special advisors, operate with self-restraint, that in Hennessy's words, they behave themselves. That self-restraint has now vanished. Trust in politicians has been lost. The failure to observe the Sewell Convention and to legislate even in the absence of devolved consent is a good example. If good chaps or chapasses can no longer be trusted to observe unwritten conventions or understandings, political constitutionalism can't work effectively. And there's a greater need for more secure constitutional checks and legally enforceable constitutional principles. Otherwise, the UK Constitution becomes ever more susceptible to manipulation by those who are definitely not good chaps or good chapasses. Hennessy is also right, however, in capturing the rather strange excitement this realization has engendered. Far from being a byword for tedium, the condition of the UK Constitution has become a first-order question, cracking with political electricity, he said. Or, as prominent UK legal blogger and commentator David Alan Green writes, constitutional law is currently exciting, but constitutional law should not be exciting. If the UK dissolves, there will be no federalism or other solution. I've ended by exploring some other possibilities to devolution or federalism. This may be exciting, it may not, but of course, there are no easy answers. And I'll conclude there. Thank you.